You know us at 90 Days from Retirement as the Medicare nerds, but did you also know that we have in our offices an unbelievable attorney who specializes in estate planning? His name is attorney Greg Lyle, and in this video, we'd like to introduce him to this channel because he is going to handle all of the things related to estate planning. Because our clients often come to us for help with Medicare and Social Security, but they're also looking to protect themselves and their assets once they move into retirement with things like wills and trusts. So Greg's going to tell us all about the difference between wills and trusts.
Today we're going to talk about the difference between a will and a trust. This is a confusing topic. This is a question that I get at least once a day, and for good reason, right? A will versus a trust. Do I need both? Do I need one? Let's talk about it. And I'm going to make it very visual for you. I'm a very visual person, so I'm going to assume that you're visual as well, of course. And we're going to walk through it, and I'm going to give you two different examples. And hopefully by the end of it, you'll say, okay, I get it. I get it. I need both. I need the one. So let's go ahead and go through it. So I think, first of all, one of the easiest ways to understand the difference between a will and a trust is to understand the old way we did things, I'll call it the old model, versus the new way we do things, I'll call it the new model. So under the old model, the job of the will was to dispose of your assets, right? So it would give everything to your heirs upon death, but it would do it through court. So the upside of that is it was easy in the way that family, you didn't have to really title anything differently. You would just own your house in your individual name. You'd own all your stuff in your individual name. And then when you died, your family would go to court. That's the downside, and go through a probate. Right now, probate's not fun. It's expensive. It's time consuming. It's not something we want to do if we can avoid it. So that's the old model, is just to pass everything through a will and through the court. Now the new model, what we would do nowadays is we would put your stuff in the trust. Now I'm making it very simple. We may or may not put everything in the trust depending on your situation. It all depends on how much control you want to exercise over certain assets. Now, I would say you got to be careful with that. Some parents or loved ones have set stipulations that are not realistic or that hold a child back or can cause harm in some instances. But really, that's the idea of a trust, is to be able to give it to your heirs when you want them to get it through these private means, right? So that's what we're doing, is we're passing your assets directly to those beneficiaries. Now, in this instance, as I mentioned before, that role that the trust is playing, that's the role that the will sort of played in the first instance, and that's why people get confused. But under the new model, the will has a totally different role. Its role is to act as a fail-safe. So where the trust already passes everything, we don't need the will to do that. The will acts, as it did in the first instance, as a court document, a set of instructions to the court to tell them where stuff goes. So if we do things right, everything should go to your beneficiaries and avoid court. But let's say that a loved one bought a property and they bought it in their individual name. Who knows why? Maybe for the speed of the transaction, or they forgot they had a trust, whatever it is. If they die and nobody owns it, well, it's going to go to court. And that's where we're glad that we have the will, right? Because now the will is going to shove it back into the trust, and it acts as that fail-safe to make court easier, make court quicker, dispose of things privately through the trust at the end of the day. All right, so that is the first example of the difference between a will and a trust. So to summarize, under the new model, the job of the trust is to dispose of things privately and make sure it goes to who you want upon death. The job of the will is to kick things back into the trust if you mess up and don't put it in the trust correctly. So let's go through another example. Again, I want to make things very visual for you, make it very easy to understand. So I think one of the easiest ways to understand the difference between a will and a trust is to understand what happens when somebody dies owning property without a trust. So what happens if somebody dies owning property without a trust? So let's use an example of a married couple. And this would be very similar if you're a single person, but let's use the example of a couple. So when you buy your property, the seller puts a deed in both your names, right? Typically, people are going to be what we call joint tenants on the property. Just means you're both 100% owners on the property. That deed is taken, it's filed with the county, and that deed is hugely important, right? Because that's what makes you the owner of your home. So if one of you dies, it's really not a huge deal legally, right? Because the other keeps owning it, keeps living there, not a problem. The problem comes in on the second person to die, because when that second person dies, all of a sudden nobody owns it, right? So your kids or your beneficiaries, whoever those people are that would inherit from you, they'd want to come in and they'd want to sell it, but they can't because they don't own it. And so we're stuck, right? And what's going to happen in that case? Well, again, they would try to sell it, but they wouldn't be allowed to because they're not on title, can't give a deed to the new buyer. They'd have to go to court. Now, if you think about it from the perspective of the county, it makes a lot of sense, right? If you work at the county and a kid comes in and says, hey, my dad died, I want to get to his house. How do you know that that's his only kid? How do you really know that's his kid and it's not, a fake ID? How do you know that he even likes his kid, right? So it really puts the person in a bad situation. And so the county would say, hey, you got to go to court and you're going to have to come back with a court order saying that you can sell this house. And that's what would happen. They'd go to court. Now, this is where you can see the role of the will again, right? The will is that set of instructions in court, telling the court what you want. If you don't have the will, again, it goes off of that default code, which can be or cannot be what you want depending on the situation. Through that probate process, you would be able to sell the home. But again, it's going to take, months to years depending on the situation and depending on the state that you're in. So there you go. That's the kind of that old model of going to court, right? Now we're going to look at inheriting with a trust. So a trust is a private contract, but think of it like a corporation. I think that's an easy way to picture it. So with a trust, there's owners and there's managers of the trust, just as there's a board of directors with a company and there's shareholders, right? Board of directors runs it, shareholders own it. Same idea with your trust. You own it, you manage it, no big deal. So we get the trust in place and we'd have the manager, which is the trustee, you, and we'd have a backup manager. That is typically going to be a family member. That could be, again, if you've got small kids, that could be a brother, a parent. If you've got kids that are of age, that could be those kids, depending on when you want them to receive it. Regardless of who it is, we will put this trust in place, and then we would go ahead and put your property in the trust. That's very simple. We do that through a simple deed. It's literally usually a one-page document that we file with the county, not a big deal, really easy to do. And now, according to the county, your trust is the owner of that property. Now, here's why that matters. So if one of you dies, same as before, no big deal, the other keeps living there, keep owning it. But on the second person to die, that's where it matters, right? Because the trust doesn't die. The trust keeps owning that property, and the new manager just steps in, files an affidavit with the county, and they can sell that property. If you think of this from the perspective of a corporation, right? Just because a shareholder dies doesn't mean the company dies. The company still owns its property. It still has other owners. It still has a board of directors that's running it. So similar idea with your trust. And I think that's a healthy way to kind of picture your trust. So that's that. In terms of where it goes when you pass away using a trust, it avoids court. And the way that it does is continuity of ownership, right? So the fact that you die and your trust doesn't die, it keeps that continuity of ownership. And so there's no need to go beg the court and ask them for permission to sell the property. Now let's delve into some questions that I get all the time from people. One is, what are the benefits of a trust? Why should I even do a trust? And there's lots of benefits of a trust. One of the benefits is you get to control when people get things. So as a dad of kids who are 12 years old and younger, that's important to me, right? I don't want my kid getting, a couple $100,000 when they're 18 and graduated from high school, which is what would happen, right? If you die and the kid's an adult. So the trust allows you to say when they get assets, what they need to do to get those assets. You could say, well, you got to go to college or you got to do this or that. And it allows somebody to invest and control those assets for them, but still take care of them with the money. A trust can provide some tax benefits. That's a whole nother presentation. We're not going to do that today, but it can provide some tax benefits depending on how much money you have when you pass away. It keeps control in terms of somebody who has drug issues or somebody who's got medical issues. Here the trust can say, well, you never inherit that fully, or this is the person who manages it for your lifetime, or here's what I want it used for. That's a huge benefit of trust. It's also private. A will is public as opposed to a trust, which is private. You can actually go and look at, like Jackie Onassis, you can look at her will. You can look at other famous celebrities' wills. Another thing is it reduces conflict. If you have a trust that's done well, it should say who gets what, and it should make it very clear. And it's also not an open lawsuit, which a probate is. So if somebody has a problem in a probate, all they do is file, a motion, right? And they're off and running. Whereas if somebody has a problem with the trust, it's a higher bar to get there and it's more money to get there. So those are some other things that a trust does in addition to avoiding probate, which we all know it does. Let's go ahead and talk through a couple questions that I get from people all the time trying to avoid having a will or a trust. And they raise some good points, and I want to make sure that I address these questions in case you have them. One is people will say to me all the time, look, my stuff is simple. I don't need a trust. Can I just do a will? And the way I respond is you can, but understand what you're getting and what you're not getting. You're not getting control. You're not getting to say when people get things. You also are making your family go to court. That's what they're getting. And it's not that's not a great thing, right? It's expensive, it's time consuming. And as I pointed out, it can lead to problems. It can lead to disputes, which run their course through court. The second question I get all the time is, can I get away with doing nothing? It's possible that you could get away with doing nothing. And by that, what I mean is maybe you don't need a will. Maybe you don't need a trust. Again, I would advise you to have one because it's not that expensive and it's pretty simple to do. But I have had a few instances where a client has said, I just don't want to do it. And they've gone their merry way and they've taken care of things. Where would that work? Well, it works if the person only has accounts, right? So let's say all they have is a 401k and they've got a bank account and they have beneficiaries and they have enough layers deep that if those beneficiaries die, it's going to go to the people they want either way. They could avoid it. Now, they can't avoid it if they have real estate typically, right? And even cars can cause probate depending. So not a great idea. I would advise against it. It's not that expensive. Just go ahead and do a trust. Go ahead and at least do a will. Another question I get, and this is from more sophisticated clients who've clearly thought about it, they'll often say, you know what? I've realized that if I have co-owners when I die, then nothing goes to court. And they're right. They make a good point. For example, if you and your spouse own a house and you add a kid to the house, would it avoid court when you die? Yeah, it would, because there's an owner that when you die, they're just going to keep owning it. Same thing with accounts. Now, why would I advise against this? And I would advise against this heavily because it can backfire really badly. So let's talk about a few instances where I've seen it backfire. One is an instance where a dad added a son to his house, and the son, for whatever reason, they had a falling out, and he said, you know what? I want to get my share of this house. And he filed a lawsuit against dad. He filed a partition lawsuit, and he was able to get his share of the house, right? And the court partitioned it. Not a good situation, not a very honest thing to do, but legally there was nothing wrong with it. Co-owners can also open you up to liability. What do I mean by that? I mean that if you add a child to a bank account, let's just say you add a kid to your bank account, it's got $100,000. Well, what if that kid gets divorced, right? And that happens, that you added them during the marriage. Well, could that be considered a marital asset? And are they now going to tie that into this lawsuit? Well, it's possible, right? Also, if the kid gets in a car wreck, all of a sudden somebody who's going after them, that creditor, they could possibly go after your account because that is considered the kid's asset. A couple other instances, if you have multiple children and you decide to add just one to an account, it's just a recipe for disaster. Why? Because legally, the kid's going to get that property when you die. So that the moment you die, that property vests in that child. I don't care what your trust says if you have a trust. I don't care what your will says. If they're named directly on that account, it's going to go to that kid. So that is scary, right? And it's scary because all of a sudden that kid's going to have all that money. They don't need to share it. Even if they're honest and they want to share it, they're going to take a tax hit. It's considered their money. And so if they want to share it, that's considered a gift, right? So that's a big issue. Also, the biggest one of all is adding real property, right? And I gave you an example of where it went wrong. Let me give you another example. So I've seen this happen a few times where a parent will add a kid to a house. Sometimes the kid doesn't even know, but the parent will add a kid to the house. And what'll happen is the parent will die. And if the parent had put it in a trust and the kid inherits it through the trust, they get what we call a step up in basis to fair market value. And what that means is when the parent bought it, let's say they bought it in the 80s, the property's been going up, and now they die. Well, the kid, if they're a co-owner, they got to pay all the gain between when they bought it, when the parent bought it, to when they died. That is a huge tax hit. Whereas if the parent would have put it in a trust and then died, the kid gets what we call a step up in basis to fair market value. So they would not pay all that gain. That is a huge difference, just a huge difference. So I hope you found those two examples helpful. Hopefully it made it more visual for you and you can understand when you are acting under that old model of just doing a will that goes to court and when you're acting under the new model. And again, as an attorney, I would advise you to act under that new model and to go ahead and plan your estate through a trust and a will. You're going to need both in most estate plans. And if you have any further questions, please just put them in the comments below. Happy to answer those. We do read those comments. And if you would please like and subscribe, we are going to be coming out with a lot more videos on estate planning.